file a motion to recuse and or change venue based on, essentially, in a nutshell, Your Honor's heard other criminal matters related to Mr. Horton, and that the court did not schedule this in a timely manner, and it was not done pursuant to the statutory requirements of the schedule within 14 days. My understanding, by way of a telephonic message, was that the motion was denied, but I would like to just at least be on the record if that is in fact the case, it was denied, and I didn't see anything in writing, but...
well, I didn't see it until it was Friday.
I understand.
Well, on the motion to recuse, I mean, you said it. I mean, I see people sometimes on a regular basis, whatever. I know Mr. Horton by name. He's been in front of me a few times. I see no reason to recuse myself on that basis. And, you know, the court would have to recuse itself time and time again, and that just wouldn't be appropriate. Plus, in fact, if I remember him right, I think he represented himself once, and I complimented him. They did a very good job. Just didn't have the facts to support his case, but he's always been pleasant with me. I don't have anything against him. The
only reason is because this is civil, the other criminal, and I understand, and I'm not arguing. This
case is a clean slate. If matters that have come before me that criminal issue, I can remember one case, two cases I can remember with Mr. Horton. I remember them vaguely, but only the other, you know, only hear that. The thing I'm concerned about, and this is the delay, as far as the court schedule. This was not the state's fault. It certainly wasn't the defendant's fault. I can tell you that what I've been told is that the summer vacations and things, and different staff taking different responsibilities. This case put on the desk as somebody who doesn't normally deal with that kind of thing and didn't realize that there's a statutory issue with respect to the scheduling. The question is what's the remedy here?
As to the remedy, there may be two remedies. One would be that his license is issued because it is a violation of his due process rights. It's his right to have that appeal, and it's a shall issue license, and therefore it should be issued. The other is, there's a subsection F, I believe, of 159.6, and F deals with remedies. Now, granted, those remedies are for a superior court action challenging the issuing authorities.
Let me catch up.
No problem. 159-6F. These are remedies that are in the licensing statute for the carry license. And these remedies are imposed when the issuing authority or employee, in other words, the chief of police or mayor selectman, fails to follow the law and you bring an injunction type action under the, which was delineated in the Grant case, of course, in Grant, in Superior Court, and if findings are made there, then attorney fees and costs can be awarded. And I've had that occur before in Superior Court on the case was Ferrara, just comes to mind. And so there is that remedy. Now that does not specifically address, of course, when the court itself, district court, doesn't schedule it within the time frame, and that remedy is not focused on the court, it's focused on issuing authorities, but nonetheless there is a remedy section there that may be instructed.
I would argue that that provision does not apply to this particular fact scenario because the chief of police did respond timely.
Yeah, I agree. I think counsel is not arguing that that applies here. He's just saying that may be instructive. I mean, there are other provisions where there are mandatory dates where there's no remedy if the court fails to honor that date, and I don't know that that requires.
I would further argue that for the court to allow him to get a pistol permit now because the timeliness was not, the hearing wasn't scheduled timely, is absurd because if he's not a suitable person to carry a concealed weapon, he's not a suitable person.
Well, then what's the 14-day, that renders the 14-day thing meaningless.
I understand, but that cannot be the remedy if he's not a suitable person, and he has not shown what in any way he's been prejudiced. I don't think he has. The court scheduled a hearing, he's here today for that hearing.
Well, to what extent does prejudice to the defendant count in my analysis of this? I'm asking both of them.
I guess I would have to hear how he's prejudiced first. I find it hard to believe that he can show he is.
Well, the reason the legislature put it on a tight time frame, dealing with constitutional right, and they wanted these things held in a timely manner, and they gave a specific time frame. They didn't just say the court can set the date. They said, here's when it has to be done, and there's a reason, and it has to do with his rights in this appeal, based on his license, which is a shall issue license. With the
Do you think the legislature would have wanted this outcome? Let's imagine someone applied for a license and it was utterly frivolous. Let's say they had the classic record as long as your arm, felony convictions that would have absolutely prohibited it, and for some reason the court inadvertently didn't schedule it within 14 days. Do you think the legislature wanted that person to possess a firearm? Possess a license?
I think the remedy would be...
Well, you're saying the remedy would be that person gets the license, right?
Gets a license, and if there's any problem future, the immediate provision is there to move to revoke or suspend, so that the license gets issued, and then the state has the remedy.
So you issue a license to a convicted felon who's not allowed to possess a license?
Well, he would not be allowed to possess a firearm anyway, so because he's a convicted felon. So if a person, the license to carry being different from the license to possess. If a license to carry is issued and he's otherwise qualified to possess a firearm, then he can carry.
So he can possess a license, that doesn't mean he may never want to carry it.
That's correct too. So the license to carry being separate from his ability to possess, if the license is granted and there's any issues subsequent, the state has a remedy in the statute itself. As a matter of fact, it's under, let's see, there's immediate 159.6b, suspension or revocation. The issuing authority, the order of license to carry issued to any person be suspended or revoked for just cause, provided written notice, etc., right there, and then it's immediate, and then there's the ability to have that hearing within 7 days of the issuing authority. So they have addressed that.
Well, we can do it two ways. Unless you have to do something else. We can do it two ways. We can just adjourn this hearing to address the issue of whether, what role the court plays when the court itself didn't schedule it in timely fashion, or we can go through with the hearing, and I can still have to address that issue, but rather than have you come back for another hearing, we can go forward with that today.
Your Honor, two things. One is, I believe this is an important issue and a genuine issue of concern. I would like to address that issue.
I'm concerned too that we missed the deadline.
I additionally have another matter in Franklin at 1 o'clock, so all things considered, I would prefer to address formally in a brief that issue for Your Honor and come back.
Do you mind doing that?
I guess the state would prefer to proceed today. The state has witnesses who've been here all morning for this hearing.
Well, I mean, I can't just ignore the issue.
But
how long a hearing would it be?
I find it hard to believe that
how long a hearing would it be?
Well, from the state's perspective, it won't be longer than a half hour, but I don't know what attorney happened has
probably 2 hours for us, please, Judge.
Think so, Rob?
Yes, there's a DVD that we have given to the prosecutor that goes through exactly why he did what he did, and with actual photography from the time on the matters that the state intends to use to deny him. So we do need a chunk of time anyway.
And with respect to the footage, I assume it's a narrated film. I think the narration is purely irrelevant to this hearing. If he wants to testify, he can testify.
I'm sorry, I didn't want to cut you off.
Go ahead.
The state did give me a packet of discovery today, and I did give the DVD to the state today, so both of us, I'm sure, would like an opportunity as well to review more thoroughly the discovery, and for you to actually view the DVD. You haven't not seen it. Plus, we have this legal issue.
Well, speaking of deadlines, your notice that went out August 13th said notify the court 15 days prior to the hearing if the hearing is expected to take longer than 30 minutes. Well,
I'd still prefer to
have the hearing.
I'd still prefer to have the hearing today.
Well, why don't we take it this far? Why don't we have the state's witnesses testify? They're here. Can't be any harm in that.
No, that's fine.
We'll at least take it that far, and they don't have to be inconvenienced again. And we'll take up that issue.
Thank you.
I guess I want the parties to consider a motion in limine or motions in limine with respect to what the anticipated evidence is going to be. so that we can address that and not have to wait until the next time we can get together here. I guess I'm talking about this videotape, you said?
Yes, Your Honor. That's
May I
fine.
just have one brief moment to confer with my two witnesses?
Sure.
I guess if the court is going to allow Mr. Attorney Appel an additional hearing on his case, and I would prefer to postpone the state's portion of that as well, and for the hearing to take place all at once.
So what I'm expecting is we'll get some people's positions on whether the court's error here results in the requiring an issuance of the license to Mr. Horton, because we didn't meet, nobody disputes we didn't meet the deadline. It's clearly stipulated. And the issue of prejudice, if in fact, I guess most people have to address that. And then I'd like you to, again, consider the motion in limine with respect to the anticipated evidence, at least as counsel has described.
Yes.
Okay. And how much time do people want to do over? How much time do you need to address it?
Let's see. Problem is, of course, other matters being scheduled, so if we...
I mean, just a time to get the paperwork in.
Oh, the paper.
Yeah.
I understand. I see.
And we can schedule a hearing
Oh,
in fairly short order.
No problem. About 2 weeks.
This time.
Is that enough? You sure? Okay.
Thank you, Judge.
We'll make it by the end of the month.
Thank you, Your Honor.
All right. I guess those will be sort of simultaneous submissions of people if they need time to reply to what they see filed, rather than have you go first, you go to the second. All right. Do you have any questions? Or do you have any questions?
I do not.
Okay.
So my understanding, Judge, is the state will be filing a motion within that time on eliminate if they choose to. And
Well, unless you can work something out. I mean, just
Okay.
if you think there's some way to either streamline it, or if you're just at loggerheads and you can't decide it, well then but that's why I want the motion filed ahead of time. Otherwise, we'll come back here, we'll raise the issue, and we'll take it, and then we'll have another issue about continuing the case.
I totally understand, and I just want to make sure I get it.
Yeah.
And then the other issue, we're both going to file simultaneous
Yeah.
as to that.
Yeah.
Thank you, Your Honor. Just wanted to clarify.
Right.
Thank you very much.
Oh, yeah. Okay. You're all set.
All set. Thank you, Your Honor.
Robert Newcomb. You can have a seat, please, at this table right here, and those that are standing at the table here.
Oh, it's not. Something left there.